Hey everyone, and welcome back to the channel. Today, we're diving into one of the most bizarre and fascinating legal showdowns in English history. We're talking about a time when Parliament tried to take down the King's best friend, and in the process, almost broke the entire legal system. This is the story of the 1626 impeachment of the Duke of Buckingham, and the question that stumped everyone. Can you put the king on the witness stand? To really get this, we need to set the stage. The year is 1626. King Charles I is on the throne, but he's new to the job and things are already rocky. His father, James I, had his own issues with Parliament, but Charles inherited a whole new level of tension. A big part of that tension had a name: George Villiers, the first Duke of Buckingham. Now, Buckingham wasn't just some noble hanging around the court. He was the king's absolute favorite, his closest advisor, and a man who held immense power. He had risen from relative obscurity to become the most influential figure in the kingdom, second only to the king himself. He was the Lord High Admiral, effectively in charge of the entire navy, and he had a hand in almost every major decision, especially in foreign policy. But with great power comes great scrutiny, and Buckingham was not a popular man. To many in Parliament and among the public, he was the source of all of England's problems. He was seen as corrupt, incompetent, and dangerously ambitious. People blamed him for failed military expeditions, for wasting public money, and for leading the king down a disastrous path. Think of him as the ultimate political lightning rod. By 1626, Parliament had had enough. They were furious about a recent failed naval expedition against the Spanish port of Cadiz. It was a complete fiasco. Soldiers were unpaid, poorly equipped, and the whole operation ended in a humiliating retreat. Who was in charge of the navy and the mastermind behind this plan? You guessed it, the Duke of Buckingham. So, the House of Commons decided to take a drastic step. They drew up articles of impeachment against him. This was a huge deal. Impeachment was a powerful tool Parliament could use to hold the king's ministers accountable for their actions. The charges were serious, ranging from gross negligence and incompetence to corruption and even accusations that he had poisoned the late King James I, a truly explosive claim. The impeachment trial was set to take place in the House of Lords. The Commons, led by fiery figures like Sir John Eliot, presented their case, laying out all of Buckingham's alleged crimes. It was high political drama. Everyone expected Buckingham to defend himself, to bring in witnesses, to argue his case. But Buckingham had an ace up his sleeve, or so he thought. He proposed a defense strategy so audacious, so unprecedented, that it sent shockwaves through the entire legal and political establishment. He wanted to call King Charles I as a witness in his defense. Just take a moment to absorb that. The man on trial wanted to have the reigning monarch come before the House of Lords and testify under oath on his behalf. Buckingham's logic was simple. Many of the charges against him were related to decisions he made as a royal minister. He argued that he was just following the king's orders. So, who better to confirm that than the king himself? If Charles testified that he had commanded Buckingham to do these things, how could Parliament possibly convict the Duke for simply being a loyal servant? On the surface, it seemed like a brilliant checkmate move. But it created a constitutional crisis of epic proportions. The moment the proposal was made, everything ground to a halt. The lawyers, the nobles, the parliamentarians, nobody knew what to do. The problem was, there was absolutely no precedent for this. Never in English history had a reigning monarch been called to give testimony in a court of law, let alone in a political trial like an impeachment. This threw up a series of mind-bending legal and philosophical questions. First and foremost, was it even legal? Could the king be compelled to testify? The very idea seemed to clash with the core principles of monarchy. The king was the source of all justice in the realm. He was the one who appointed the judges. How could the fount of justice be subjected to it? Then there was the principle of the king can do no wrong. This was a cornerstone of English law. It meant that the monarch, in their political capacity, was legally infallible and could not be prosecuted for their actions. It created a paradox. If Charles admitted he ordered the failed Cadiz expedition, was he admitting to wrongdoing? But the law said he couldn't do wrong. The whole legal framework started to buckle under the weight of this single question. Witnesses in court had to swear an oath to God to tell the truth. But the king had already sworn a coronation oath to God to uphold the laws and govern justly. Could he even take another oath? And who would administer it to him? It would be an incredibly awkward and potentially demeaning spectacle for the monarch. The members of the House of Lords were completely stumped. They debated the issue furiously. Legal scholars were consulted. Ancient texts were scoured, but there were no easy answers. Calling the king seemed to violate the sanctity of the crown, but denying a defendant the right to call his most important witness seemed to violate the principles of a fair trial. Imagine the dilemma. If they allowed Charles to testify, they would be setting a dangerous precedent. It could open the door for the king to interfere directly in legal proceedings whenever he wanted, potentially undermining the independence of the courts and parliament. The king's testimony would be impossible to question. Who would dare cross-examine the monarch or accuse him of lying? His word would essentially be a royal decree, ending the trial on the spot. It would make a mockery of the entire impeachment process. On the other hand, if they refused to let Charles testify, Buckingham could claim he was being denied justice. He could argue that the trial was a sham, a political witch hunt designed to find him guilty regardless of the facts. This would look terrible for Parliament and could be seen as an act of tyranny in its own right. While the lawyers and lords were tearing their hair out over this legal black hole, King Charles I was getting increasingly angry. He saw the impeachment of Buckingham as a direct attack on himself. In his view, Buckingham was his chosen minister, and questioning the minister was the same as questioning the king's own judgment and authority. He had no intention of letting Parliament push him around. Charles went to the House of Lords and gave a fiery speech. He made it crystal clear that Buckingham had acted on his orders and with his full approval. He essentially testified, but not as a formal witness. It was a royal command, a threat. He told them, "I will not allow any of my servants to be questioned amongst you, much less such as are of eminent place and near unto me." He was drawing a line in the sand. He was telling Parliament to back off, or else. This intervention only made things worse. It confirmed Parliament's worst fears, that Charles was willing to ride roughshod over the law to protect his favourite. The standoff was complete. Parliament wanted to convict Buckingham, but they were legally paralysed by his proposed defence. The king was determined to protect Buckingham, even if it meant blowing up the Constitution to do it. So, how did it all end? Well, King Charles decided he wasn't going to wait for the lawyers to figure it out. Seeing that Parliament wouldn't back down and that the impeachment was heading towards a constitutional meltdown, he took the most drastic option available to him. He dissolved Parliament. He simply sent everyone home. Poof! No more Parliament, no more impeachment trial. The problem was solved, but in the most destructive way possible. By dissolving Parliament to save his friend, Charles sent a clear message. He believed his royal prerogative was above the law and above the will of the people's representatives. This act of royal defiance was a critical moment on the road to the English Civil War. It deepened the mistrust between the Crown and Parliament and set the stage for years of conflict. As for Buckingham, he was saved, but not for long. 2 years later, in 1628, he was assassinated by a disgruntled army officer named John Felton, who, like many, blamed Buckingham for his personal and the country's misfortunes. The bizarre legal question of whether a king could testify was never formally answered. It was sidestepped by the raw exercise of royal power. But the incident remains a powerful illustration of the clash between monarchical authority and parliamentary rights that defined this tumultuous period of English history. It showed that sometimes the law simply doesn't have an answer, and when that happens, power is often the only thing that does. It's a fascinating what-if that reveals the fragile foundations of a system of government under immense stress. What do you think? Should the king have been allowed to testify? Was it a clever legal move or an abuse of power? Let me know your thoughts down in the comments. Thanks so much for watching, and if you enjoyed this dive into history, don't forget to like, subscribe, and hit that notification bell so you don't miss our next video. See you next time.